by the general form of complaint dated 12th day of March 2019 and filed on the same date, accompanied with statement of fact, witness statement on oath, list of witnesses, list of documents, and photocopies of documents to be relied on at the trial. On the 9th day of October 2019, the claimant sought for and granted leave by this honorable court to amend statement of fact and deemed the amended statement of fact already filed on the 24th day of July 2019 as having been properly filed and served. The defendants, upon receipt of the claimant's originating processes commencing to file its statement of defense, wherein it incorporated a counterclaim. In the claim of the claimant is claiming for the following reliefs. One, a declaration that the action of the defendant against the claimant while he was on his lawful duties was illegal and amounts trespass on his person. Two, declaration that the claimant is entitled to compensation for injuries sustained and pay off for the employee of the defendant. Three, general damages in the sum of 25 million naira as compensation for the employee for the compensation for injuries, items, lost items, and employee of the defendant. On 10th day of October 2023, the defendant was granted leave by this honorable court to file additional witness statement on oath, which was filed wherein the witness statement of Mr. Obono Eteng Opem's written address was filed by the defendant. In the counterclaim, the defendant counterclaimant is claiming for the following reliefs. One, the sum of 30 million naira being cost of crusher destroyed by the defendant to the counterclaim. Two, a declaration that the defendant to the counterclaim breached his contract of employment with the counterclaimant when he abandoned his employment with the counterclaimant. Three, the sum of 100 million naira for breach of contract. Four, the sum of 882,918 naira as being special damages suffered by the counterclaimant for the unwholesome act of the defendant to the counterclaimant in pushing Mr. Zufene into a pit. The sum of 10 million naira as general damages. On the 8th of January 2020, the claimant in proof of his case testified as CW1. CW1 adopted his two witnesses' statement on oath as its evidence in this case. Documents were tendered through CW1. They were admitted in evidence and marked as Exhibit A to M. On the 6th day of June 2022, when CW1 was examined, additional documents were tendered through him. They were admitted evidence and marked as Exhibit QPOPQ. After cross-examination of the defendant's witness, of the claimant's witness, the claimant was discharged. The defendant opened its case on the 1st of February 2024, with Obono Eteng Open testifying as DW1. After adopting his witness statement on oath as evidence, in this case, he tendered documents which were admitted in evidence and marked as Exhibit D1 to D17. DW1 was cross-examined by the claimant counsel on the same day, and the defendant closed its case. The case of the claimant. I will keep reading this one. The case of the defendant too, I will skip reading it. The submission of the defendant where a single issue was formulated and argued. I will also skip reading that. Then the claimant submissions, also I will skip reading that one. I will just go straight to the reply file therein. I will go to the decision of the court. I have considered the processes filed by the parties, the evidence laid at the trial, and the written and oral submissions of counsel for the parties. In an adjudication, the parties and the court are bound by the reliefs claimed. The reliefs are what the court is bound to determine. The court can grant all or less, but not grant what was not claimed or more than what was claimed. See Eagle Super Park Nigeria Limited versus ACB PLC. See also Osuji versus Ikiocha. Therefore, this court is bound to adjudicate on the basis of the case put forward by the parties. In the case at hand, this court is to determine the claim of the claimant based on his reliefs as claimed in the amended statement of fact. And for the defendant counterclaim, based on the relief sought in the counterclaim. However, before proceeding to determine the claim of the counterclaimant in this case, I need to determine issue of jurisdiction to hear and determine this suit raised by the defendant. The counsel for the defendant asked a question: is this court, I quote, is this honorable court the proper forum to entertain dispute arising from the torts of personal trespass, whether occasioned by co-workers or for one which he defendant is held vicariously liable? Counsel answered the question in the negative, i.e., that is to say, not all disputes that emanate from workplace that can be brought to the National Industrial Court. Counsel contended that intentional torts like personal trespass cannot be tried by this court because the jurisdiction of the court has not been expanded to accommodate them. According to counsel for the defendant, the case of the claimant is not an unemployment or labor issue. This is a case of two workers who fought. There is no single claim of exhibit to show that the claimant's employment was threatened or that the interference of this court is needed to safeguard his employment right. It is submitted that, assuming but not considered that some of the scenarios painted by the claimant are true, then the right place to ventilate his grievances will be in the High Court of Cross River State by Section 272 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Counsel further submitted that the National Industrial Court cannot adjudicate over matters of intentional tort that require proof beyond reasonable doubt. Counsel also submitted that provisions of Section 2541 of the Constitution of the Federal Republic of Nigeria, which is basically to the effect that National Industrial Court is vested with jurisdictional competence to entertain and determine all matters pertaining to labor and employment, does not avail or accommodate case that must be proved beyond reasonable doubt, and especially not one purportedly done by a co-worker. See, Aina Bedo versus Edo State University Workers Farmers Multipurpose Cooperative Society and others. The counsel for the claimant, in his response to the issue of jurisdiction, has in his reply on point of law tag addendum to claimant's final written address, contended that this court is fully seized of jurisdiction to hear and determine this case as it is currently constituted. Counsel refers to Section 2541A of the Constitution of the Federal Republic of Nigeria as amended, which created this court, which created and expanded the scope of jurisdiction of this court and matters arising from workplace. Counsel submitted that any rules of court inconsistent to the provisions of the Constitution would be null and void, and to the extent of this inconsistency, counsel submitted parties are agreed that the issue arose from the workplace. It is erroneous for the defendant to argue that this court lacked jurisdiction to entertain them. Looking at the submissions of counsel, it is clear to me that the counsel for the defendant's applicant's objection is predicated on the assumption that the claimant's claim being on assault amount to both criminal and civil matter, and this court does not have jurisdiction to entertain criminal matters. The counsel for the defendant seems also to hold the view that this court does not have power to entertain violence at workplace. The issue of jurisdiction of the court to try a suit is a fundamental and threshold one. This is so because if a court has no jurisdiction to determine a subject matter of the suit, or that the parties are not subject to the jurisdiction of the court, the proceedings thereof are and remain a nullity, however well beautifully conducted, and the judgment brilliantly written and eloquently delivered. Therefore, it behoves on every court, including this court, to carefully examine the uses in the issues in the statement of claim to determine whether the issues sought to be ventilated before it are within the jurisdiction of the court. In essence, jurisdiction is a radical and fundamental provisions for adjudication that does not exist in vacuum, as well as as well as all courts of law derive their jurisdiction from either the Constitution or statute establishing the court, or even international law and conventions. Therefore, no court can assume jurisdiction without having been constitutionally or statutorily empowered to do so. See Boko versus Nungwa and Adetayo versus Ademola. See also the court versus judicial tribunal. In determining jurisdictional of the court, claim before the court is what will show how the cause of action arose and where and under which situation a plea under which situation as pleaded by the claimant will be considered in order to be able to discern whether the case's action as adumbrated in the claim is within the jurisdiction of the court. In the instant case, the pleading of the claimant has clearly brought out facts on how the two members of staff of the claimant, Mr. Zufeni and Mr. Lauza, have allegedly unleashed violence and harassed the claimant. The claimant at workplace, so this court has absolute jurisdiction over these causes by virtue of Section 254C1 F, G, and H of the 1999 Constitution. So this court has absolute jurisdiction over these causes by virtue of Section 254C1A, F, G, and H of the Constitution as altered, and can accordingly grant the necessary reliefs by virtue of applicable ILO convention standards in combination with sections 13, 14, 15, and 19D of the National Industrial Code Act 2006. See also Salami versus National Judicial Council, and also Oman versus Answer, where the extent of the exclusive jurisdiction of NICN on all matters of employment, labor matters, and matters incidental thereto arising therefrom are admirably stated. Impertinent to state that the claimant's reliefs are three in number. Relief 1 is for declaration that the defendant against claimant in the course of performing his duty is illegal and amount to trespass to his person. Relief 2 Relief 2 is for declaration that he is entitled to compensation for injuries sustained and payoff from employment. Relief 3 is for general damages in the sum of 25,000 as compensation for injuries sustained and loss of items and payoff to the claimant from employer of the defendant. Looking at the reliefs and the pleadings, the claimant, which this court is bound to look at in determining whether employment took place within the took place in the course of his employment at the workplace environment of the defendant. I have no doubt in my mind that there is no dispute that relief 2 and 3 are clearly within the purview of Section 254C1 of the Constitution as amended. Therefore, this court has the requisite jurisdiction to deal with those reliefs. For relief 1, which is for trespass to person, there had been argument for and against the jurisdiction of the court in respect of tort. Section 254C1 of the Constitution as amended that has imbued this court with requisite jurisdiction to deal with those reliefs. The one which is trespass to person, there has been argument for and against the jurisdiction in respect of tort. This has been a thorny issue that has lingered and remained with us. The next issue of jurisdiction of the court on tort keeps recurring. Attempts have been made in determining the actual scope of jurisdiction. Some decisions have it that NICN does not enjoy the uncertainty trailing the issue of court jurisdiction on tort has been one of the focal points of discussion in a keynote address delivered in NECA National Labour Adjudication Forum under the theme Labour Adjudication in Nigeria, the Present and Future, which held on the first day of February 2023 at the main auditorium of NECA in Lagos. In a recent decision of this court, Enugu Division, the issue of jurisdiction of the court on workplace defamation for tort where the court, after appraising all the available decisions of this on the subject matter, side with the second school of thought, which conferred jurisdiction of this court to entertain claims bordering on workplace defamation and tort in general. The advent of Sad Arbitration Act establishes National Industrial Court of Nigeria as a superior court of record and a court the jurisdiction of the court is essentially found in Section 254C1A and Section 7 of the National Industrial Code Act. By virtue of Section 234, Section 2547 and 71 have made it very clear that this code has exclusive jurisdiction in civil matters and causes relating to labor, including trade union and industrial relations, environment, conditions of service, health, safety, and welfare of labor, and matters incidental thereto. The jurisdiction of NICN extends to all matters related to incidental connected with the labor employment dispute. In effect, its exclusive jurisdiction extends to matters having nexus intricably linked or reasonably connected to labor is not only a word in the English language, but also a concept in the law of employment. It is in its ordinary usage. Labor refers to those who work in contrast to those who own or manage, but a concept, but a concept. Labor is the broad powers of the National Industrial Code under the Constitution as amended are to exercise jurisdiction vested in it and in every cause or matter grant, grant absolutely or on such conditions as it may deem fit. The National Industrial Code is also empowered to make use of ILO conventions, treaties, standards, and protocols. The need to eschew unfair labor practices and the need to ensure establishment of international best practice in labor and employment relating to Nigeria. Relating to the provisions of Section 2541D, E, F, G, and H contemplated the above provisions by giving this court additional jurisdiction to prevent unfair labor practice, enforce fundamental rights provisions of the Constitution, implement employment relations, prevent discrimination at workplace, and to apply international law, labor, and international labor and employment conventions, treaties, protocols ratified by Nigeria. Labor standard Nigeria ratifies. Convention 155 on occupational policy for safety and health, Convention 1981, ratified by LEO, goes to show that the term workplace covers all places where work needed to be done or go by reason of their work and which under the direct the direct or indirect control of the employer. It is not in doubt that the action complained of took place at workplace environment. See Convention 190, which deal with violence and harassment Convention 2019, which now provide for issues. Convention 190 is equally applicable in Nigeria by virtue of the constitutional mandate placed on this court to apply ILO standard without the requirement of ratification and any equal standard being manifested in convention treaties. By virtue of the provision of Section 254C5 of the 1999 Constitution as amended, the words Nigeria shall have the exercise jurisdiction of power of criminal matters and matters arising therefrom, any cases or matters of which jurisdiction conferred on the National Industrial Code by this section or any other section. It is clear from the provisions of the Constitution cited above that this code and the Convention 190 on harassment, it is very clear to me that NICN has requisite jurisdiction to entertain this suit, and I hereby so find and hold. I now turn to the claim of the
As the
claimant.
court please.
The reliefs have been reproduced in the earlier part of this judgment. The claimant is claiming two declarations, the first of which want the court to declare that the action of the defendant agent claimant while on lawful duty was illegal and amount to trespass on his person, while the second declaration is that the claimant is entitled to compensation for injuries sustained, lost items, the claimant is claiming two declarations and one other reliefs. The two declarations the first declaration is for declaring claimant of duty lawful and amount to trespass in person, while the second declaration is that the claimant is entitled to compensation for injuries sustained, lost items, and pay off to the claimant from the employer of the defendant. It is clear to me the two declarations being sought are the main reliefs, while the third relief, which is an ancillary claim, depend on the success of the other reliefs. The law is settled that he who asserts must prove. This is in civil case, the burden of proof lies on the claimant pursuant to section 131, subsection 1 and 2 of the Electoral Act. In civil cases, the claim presented by the claimant is won and lost based on the pleading. Secondly, on evidence the evidence of the claimant is that he was employed by the defendant as excavator operator on 11th of April 2018. He and his fellow excavator operator, name withheld, not to disclose, while working on the quarry, they were confronted by Mr. Zui Penny Oshopo, a Chinese national accusing them of feeding the crusher with big boulders. In a bid to prove to them, he asked them to follow him to the crusher. On reaching where the big boulder were, the claimant explained that his excavator with a small bucket could not have carried out such a big stone. And in the ensuing argument, Mr. Zhu Mr. Zhu became infuriated and slapped the claimant and gripped him on his shirt. As the claimant struggled to wriggle out, Mr. Zhu became infuriated and slapped the claimant and gripped him on his shirt. As the claimant struggled to wriggle out, Mr. Zhao, another according to the claimant, he was assisted by a motorcycle rider who conveyed him to the main road and was transported to Calabar, where he lodged complaint as a police headquarters. He opted to take in traditional bones specialist and he demanded for compensation from the defendant. Under cross-examination, the claimant testified as DW1 maintained that he worked as elevator operator for the defendant. Mr. Du is head of excavator. The incident occurred far from the gate. The defendant in his defense denied the claim of the claimant and went on to accuse the claimant of fighting at work and punishing Mr. Zhu and Mr. Lau. Under cross-examination, DW1 testified that DW1 was asked about exhibit D11 and he answered that it is for X-ray for Mr. Zuri. He, he knows that was mere proof that traveled to Abuja. He never traveled to Abuja in April 2020. He did not travel to Abuja with Mr. Zhu. He was not in hospital with him. He told the court spoiled crusher. He does not know. He does not know. The counsel for the claimant has argued that the claimant forced proved entitlement to all the relief sought, while counsel for the defendant argued that the claimant did not establish any case. It is clear to me that the claimant's pleading before the court is less with facts constituting the reliefs. On declaratory reliefs, the lower court is well settled that claim for defamation it is clear from the fact that the foundation of the claimant case is built around the fight he had with the employees of the defendant, in the process of which they pushed him into a valley of 13 feet, which resulted in him not having it, which led him to having fractures, dislocation, etc. The law case is not fought outside the reliefs. CO2 versus O2 is so where there is no relief sought in a case, court will not have jurisdiction to award any relief in support of that. The relief sought in a matter as the phrase asked by the litigant as contained in the abandonment of facts. They are the question, they are the request that a party document or this court on the basis of vicarious liability. So even if the case is tried and the claimant is proved to have remedy will endure to the benefit of the claimant, leaving his position unchanged. What goes what goes to trial is the entitlement of the relief claim based on based on pleading. The facts pleaded highlighted the course of action which determines the relief claim for. The relief demand that the course of action be remedied if the relief is contained or the claim is abandoned. Relief has also been described as live wire of the action. It puts specifically demand in the defending language the course of action. It is the bedrock of the entire action. The action can either stand or fall based on the relief sought. In the case at hand, the relief claimant is claiming as per his amended statement of facts. The court's duty is only to adjudicate on the claim or ratify every pleading contains statement in a summary form of materials which the party pleading relies for his claim. If no relief is claimed in the statement, it is true that the court normally should not grant a relief not sought by the parties, where a party makes abandonment, but such abandonment will not relate to any reliefs sought in the case, the court will not grant such relief. See Osalade versus Osalade. The claimant first relief in this case is for trespass to person. In law, there are three types of trespass to person, i.e., assault, battery, and false imprisonment. However, due to the nature of the facts, due to the nature of the facts, reference to trespass to person means assault and battery. The position of the law as an allegation of the commission of crime on the person is on. The allegation the position of the law is that allegation of commission of assault on a person is an allegation of commission of crime on the person by the Evidence Act. Such an allegation, whether in civil or criminal proceeding, must be proved beyond reasonable doubt and not on the balance of probabilities. According to the definition ascribed to the word assault in the online edition of the Black's Law Dictionary, it describes assault as the threat or use of force on another that cause that person to have reasonable apprehension, imminent harm or offensive contact. The act of putting another person in a reasonable fear of apprehension of an imminent battery by means of an act amounting to an attempt or threat to attempt commit battery. Civil assault is equally defined as an assault. The evidence required in establishing assault is that, as per Section 138, is beyond reasonable doubt. However, as a civil matter, a claimant, if able to prove his case, can succeed, even can succeed. As pointed out earlier, proof in civil cases is on he who assert. Claimant who assert trespass to person has burden to start with the claimant's evidence on trespass to person. It is based on the assertion of that one Mr. Ju employee of the defendant with the came came to him together with his colleague and excavator operator and accused them of spoiling crusher by sending big boulders, to which claimant refute. And the event states that his excavator as small bucket cannot carry big boulders. When they went to where the crusher was, an altercation ensued, and Mr. Juice returned to deduct claimant's salary. As a result, which was his practice, as a result, his life at slightest provocation, Mr. Zhu slapped the claimant and gripped his chest. While he was struggling to free himself, another Chinese staff joined and they pushed the claimant into a valley of certain pit where he got injured. It is interesting to note that the witness called by the defendant, who claimed to be at the scene of the incident, stated that Mr. Zhu never threatened claimant, nor got hold of him either. It was claimant who gripped Mr. Zhu, and when Mr. Lau Zhu came to came to separate the fight, the claimant being huge in stature and build muscle pushed the two of them into the pit. In the process, he fell into a pit, but he quickly came out because he was not injured and filed and fled away. The claimant is evidence under cross-examination maintained that Mr. Zhu threatened staff to threaten him with deduction of salary in accordance with as he has done it twice to the claimant and also other staff. The evidence of the claimant on the practice of Mr. Zhu threatening and deducting salaries in the past and slapping need corroboration. As a law, evidence of practice to be has to be corroborated for it to have evidential value. As also not called any staff that is salaried by the counsel for the claimant has doubted, counsel for the defendant has doubted the claim of the claimant in being pushed into 13 feet because Exhibit C stated that the valley where claimant was pushed was 18 feet. From the state of the pleading and evidence adduced, the claimant has not proved trespass to his person by the claimant. If the claimant has any cause of action, is against Mr. Zhu and Mr. Lau, whom he alleged to have trespassed into his person. I agree with the counsel for the defendant in his submission that reliance on while relying on the victim of Caribbean JSC of blessed memory, as is to say, in the case in the case of Agbola, that vicarious liability arises in negligence and not in intentional tort. I now turn to second relief, which is on injuries sustained by the claimant. The witness that testified at event that there was a fight between the claimant and Mr. Zhu and Mr. Lau. The point of difference is on I have also observed that reliefs 2 and 3 by reliefs 2 and 3 are vague and uncertain, and the court has depre- deprecated the practice of drafting vague and uncertain reliefs. In the case of University of Jos versus Dr. Ikweguaha, reported in 2013, a claimant had a claim that is vague and lacks certainty is no claim at all. In the instant case, in paragraph 13b, the respondent's statement of claim, he sought an order the respondent did not state with certainty what his allowances are or entitlement were, and how he earned his promotion from one grade to another, and for which period. These vital facts are not backed by any evidence. All the reliefs regarding promotion allowances and entitlement were wages, uncertain, unascertainable, and lacking in peculiarity and good. Furthermore, these reliefs being within the realm of special damages need to be specifically pleaded, particularized, and strictly proved. See NNPC versus Clipper Limited. Claimant having vaguely stated these reliefs have not proved the quantums and how he came about the quantum. The reliefs are not capable of being granted. I would also like to state that the story told by the claimant, how he was thrown into the valley and how he was rescued, and how he was rescued and when he was thrown into the valley, he sustained not only external injuries and fractures, stroke dislocation, but internal injuries in form of thunder and headaches The evidence of claimant on injuries, as stated in his pleading, and evidence are not capable of establishing the alleged injuries. It is foolhardy to believe a human being. The evidence of claimant on injuries, as stated in his pleading, and evidence are not capable of establishing the alleged injuries. It is foolhardy to believe that a human being that had not only sustained external injuries and fractures, stroke, dislocations, and internal injuries will immediately after having accident when he was bleeding profusely be able to mount a motorbike to the roadside when he had told this court that the incident happened far from the gate and that the defendant had a very wide compound, had a very big compound. His story was even made more unbelievable when considering that despite having the kind of injury he described, he entered a public transport and traveled from Akampa to Calabar, to capital of Cross River State, lodge complaint. I do not believe that the claimant had given accurate perspective of what happened on 11th day of April 2018, the date of the accident. The exhibit being touted are not more than mere paper without any evidential value. As the most and there is nothing in it to show that shows claimant sustained the fractures or dislocation. Likewise, its exhibit G is just a mere hospital card, is not capable of showing or establishing that the person that had the hospital card had consulted a physician. The card is only an evidence to show that the bearer has a medical has a file open for him to consult doctors for treatment. The two the most laughable of all the exhibits are exhibit O, P, and Q, showing the claimant posing in a photograph with his hand and with bandages on his hands and legs, having some pieces of sharps tightened on the right leg. The photographs have no any evidential value, as the taker of the photograph was not called as a witness and he has not been tendered for cross-examination. The for cross-examination. Exhibit C and H letter of demand are also not capable of proving any claim. They are only evidence to show that the claimant has demanded for what he has demanded in them. For the mobile phones and 45,000 naira, they are claims for special damages, which I have earlier stated, they have to be specifically pleaded, particularized, and strictly proved. On payoff, this is a claim for special damages in which claimant is by law required to state the instrument that granted him right of payoff when he had not shown that he resigned or retired from his employment or his employment has been terminated. Above all, he has not stated any specific amount for the claim. If I may borrow what told JCA of blessed memory said, it is clear to me that the, the way and manner the claimant's pleadings are relieved to were drafted left much to be desired. As courts are not carpenters' workshop to toil and mend, this court will not be in a position to make amend of the processes filed by the claimant. The claimant it is the duty of the claimant and not that of the court. In leaving for those gaps that have been left and feel to be filled, from all I have been saying, the claimant has woefully failed to prove any of the relief sought. The claimant woefully failed to prove any of his reliefs, and same is hereby dismissed. Decision on counterclaim. The law is right. Counterclaim is an independent action. A rules of evidence in terms of proof applies like in the case of claim. I have already reproduced the counterclaim in the earlier part of this judgment. Therefore, there is no need for producing them again. The dependent counterclaimant's case is that of special damages and also claim on contract of employment. Apart from relief B, all other reliefs for the special for special damages. My decision in respect of requirement of proof also applies to these reliefs. Reliefs A is for 30 million naira cost of crusher. There is no evidence to establish that the claimant spoiled any crusher of the defendant, and all the evidence given was mere suspicion that it was the claimant that spoiled the crusher. No evidence to establish that. Even if claimant spoiled the crusher, there is no evidence based on which the contract between the claimant and the defendant shows that there is no evidence based on which this court will be able to determine whose responsibility is it to pay for damages of crusher. There is also no evidence to show if the said crusher had even spoiled beyond repair. There is also the cost of there is also no evaluation from an expert as to the cost of the said crusher. The claimant has failed to prove entitlement to 30 million naira as cost of crusher. Same is hereby dismissed for lack of evidence. On breach of contract, the law is clear whether it is claimant or defendant that is in default, damages that is in default. What is payable is damages for the period of notice that the claimant or the defendant is entitled to for determination of the contract. And in this case, there was no claim by the defendant for determination of the contract. However, there is evidence which has not been controverted that the claimant, after the incident of his fight with two staff of the defendant, fled and never came back to the office. This clearly shows that the claimant has failed to perform the duties he has agreed to perform. And no such, despite this breach, the claimant, the defendant, counter-claimant, is not entitled to the claim of 100 million naira. As I pointed out, is only entitled to amount for period of notice, and that has not been claimed. On hospital bills of 882,918, the witness tendered in evidence Exhibit D2 to D15 in support of the said claim for medical bills, which he purportedly spent on Mr. Zhu. In fact, DW1 stated he was not at the hospital with Mr. Zhu, as he did not travel to Abuja with Mr. Zhu. So it and that the treatment were carried out in respect of those the treatment carried out in respect of those those exhibits were not done in his presence. Therefore, DW1 is not an appropriate witness to testify on the issue of medical tests in respect of laboratory tests and treatment given to Mr. Zhu. It is either Mr. Zhu himself or the person who issued those documents that are supposed to have come and testify before the court. What the defendant has done, what the counter-claimant has done, is to dump document on the court which the law deprecates. Relief E is also not grantable, as the said relief is an ancillary relief that depends on the success or failure of the other heads of reliefs. The main reliefs having failed, the ancillary relief must also fail. From all I have been saying above, both the claimant and the counter-claimant have willfully failed to establish their cases before the court with concrete and admissible evidence. In the circumstances, the case of the claimant and that of the counter-claimant fails, and all are hereby dismissed. I make no order to post. Judgment is entered accordingly.
As the court pleases.
As the court pleases.
Yeah.
My Lord, we must appreciate the court for the painstaking judgment just delivered. It's a clear case of Daniel coming to justice. We thank my Lord.
We are welcome. Yes, Registrar.
Thank you, my Lord. May I wish you a very enjoyable holiday.
Thank you very much. I wish you the same thing too.
My Lord, that's all for today.
Okay, thank you very much. Counsel, thank you very much for being with us. We have come to the end of today's sitting. Thank you very much.
Thank you, my Lord. It was a privilege being here, sir. Thank you, sir.